really honored to be with you today and deliver this lecture. So the topic I've chosen today is publishing in the field of books, newspapers mainly, and the intersection between the publishing industry and copyright. We will see that there are, as I said in the title, conflicting interests. I actually will mention a very important Indian case of 2016 in the publishing industry and copyright. So let me share my screen, and I think now you are able to see my screen, right?
Yes, sir, we can see.
Okay, good. So book publishing is very important. It transforms ideas into books. Publishers are necessary in order to get books out, right? Authors, they need publishers. They are the intermediaries, right? Throughout the centuries, publishers have been providing services such as binding, book lending, marketing strategies, several services which are necessary for a success of the book, right? So it's their commitment, it's their task, which is a fundamental task. Without publishers, probably authors would not be able to make their voice heard in books. Journalists could not really make their voice heard outside. Of course, nowadays with the internet, we have the case of journalists who write articles in their own websites. But being part of a big newspapers supported by big publishers is important, right? So it is through this process, the publishing process, that information can be distributed, enhanced, and given economic value, especially through marketing techniques, right? So there's a kind of division of labor here. The authors, the novelists, the journalists focus on the intellectual work and activity. The publisher is tasked with the managerial, with the economic activity of producing the book and distributing it, or producing the journal, the newspapers, and disseminating it, right? Publishers, they do need copyright to ensure what? To ensure and to make sure that investments are recouped. I mean, book production does have a cost. Newspaper production does have a cost, right? How do you recoup such investments? How do you pay your journalists or big novelists? You need a legal tool, and this legal tool is copyright, right? A monopolistic rights which is used to fund these ventures in the publishing industry. Of course, nowadays, the digital and internet environment has changed the scenario in the latest 20, 25 years. Internet has created electronic marketplaces. Books are no longer just seen or read. Now can they be heard? Ebook, audiobooks, for example, right? And retail has become e-tail, right? So every aspect of book production, the creation of the work by the novelist, the printing, the distribution, the sale, even the consumption of the book has been impacted by the digital internet revolution, right? And therefore the markets have changed. They have gone electronically. Not completely. There are, of course, also always there are still books which are produced in traditional way, paper books. So challenges, opportunities, and challenges stem from the digital internet revolution. New technologies, of course, reveal new streams of revenues for publishers. Because the same publication can be now sold, distributed electronically to a potentially wider audience. The costs for an ebook are much lower than the cost of producing a traditional book, right? That's quite obvious. Journals, books have become non-rival goods. Cost of production in this sector has been, cut. Of course, there are also challenges. Technology advances, and with such advancement, we have much more massive piracy, copyright infringement, which is facilitated by the digital environment, threatening a publisher's position and profitability. Publishers often respond to such digital challenges by relying on copyright, for example, lobbying for new rights. We will see later on the newly EU publishers' rights. They fight by, strengthening their contractual positions, copyright contractual position, and so on and so forth. So, as I wrote in this slide, book publishers wear many hats in the value chain. They can be managers and kind of custodians of IP rights created by others. So novelists, for example, authors, journalists, they create the intellectual work, and the publishers, they take care the rights by also acquiring sometimes the rights from the journalist or from the author. Publishers also have a fiduciary duty and the moral obligation to treat IP of others, third parties, with great respect, right? You may know that the publishers, of course, they make sure that no rights of others, copyrights, are infringed when it comes to publishing and then distributing the book. So IP, specifically copyright, is a valuable tool in the publishing industry, okay? By looking at the history of publishing, after Gutenberg, right, the invention of the printing press, 15th century, publishers historically have been relying on privileges. It is true that the first copyright statutes, I'm thinking about the Statute of Anne at the beginning of the 1700, right? 1710, 1710, the Statute of Anne. These first copyright laws gave authors, not publishers, rights over their book, the intellectual work. That's true. In theory, authors were the right owners. In England, in the US, later on. However, publishers had always been able to remain the strong contracting partner throughout the centuries until now. Publishers have been always able to put pressure on novelists, poets, journalists, academics, and other categories of authors with the purpose of obtaining the rights via transfers, for example. So even if the novelist, the author, was in theory the first copyright owner, ab origine, well, the way the market was structured, and is to some extent is still structured nowadays, made sure that the rights would end up in the hands of publishers, because they still are, in many cases, the strong party. Unless you are J.K. Rowling and you are very rich and very powerful, of course, in that case, the stronger contracting party is the author, but 99% of the cases is the publisher which has the upper end, in the negotiations when contracts are signed. Why has always been like this? Well, because publishers are able to offer something which authors cannot do. High-profile services, as I said before, printing, binding, designing the cover or the entire book, book packaging, distribution strategy, marketing, say, I mean, these are services that, single authors cannot really carry out. So they end up being the weak party, and they have to transfer the rights under pressure. They're under pressure. Or a license on terms which are usually dictated by the publishers, okay? So, what is here, I mean, the relationship? We need to look at the relationship between publishers on the one hand and authors, because the first tale of conflicting interest is here. Is there a tension potentially between publishers and authors? Well, there might be. And the area of moral rights, especially the integrity right, is here important. You may know that the moral right of integrity, under most copyright laws around the world, authorizes, empowers the author, gives the author the right to object to any treatment of the work which is prejudicial to the honor and the reputation of the author, right? Well, you may be aware of the fact here if that, a author might be quite reluctant in a contract with a publisher to waive, to renounce, to abandon these moral rights. But since, as I said before, publishers have often the upper hand in the negotiation, especially in common law jurisdictions where moral rights can be waived, well, the publishers really exercise pressure, put pressure on authors, on novelists, on journalists, to convince them to waive moral rights of integrity and other moral rights, such as attribution rights. For example, by offering a higher amount of money. It is clear that if moral rights are waived by the authors, publishers have more freedom. For example, more freedom to publish a second edition of the book, to change certain parts without the artist being able to object, because he or she has waived the moral rights. So, but this cannot happen in civil law jurisdiction, continental European systems and some Latin American systems. I mean, in these countries, moral rights cannot be waived, and therefore publishers have less freedom there, okay? I want to cite a case. It was a case about, not about, strictly speaking, publishing, book publish. I mean, it was yeah, basically here, the book Les Miserables, the work Les Miserables by Victor Hugo was, created by Victor Hugo in the 19th century. What happened here that the death sentence died in 1885, recently litigated a case in France opposing the reinterpretation by someone else of Les Miserables, right? They claimed that that was in violation of Victor Hugo's moral rights. Well, the French Supreme Court did not agree, and if they found that such sequels to Victor Hugo's work would be allowed to be published in principle. But in France, as you can see, the death sentence of a person who died more than 100 and 35, 40 years ago almost, was the descendants were able to litigate by trying to enforce the moral rights of a person who died 140 years before. Quite strong. The other tension which may arise is between publishers and users. So here the question is, to what extent copyrighted works can be used without the, the authors, the publishers, for example, the publisher's consent? Here we have the concept of fair use under US law or fair dealing under UK, even Indian law, right? How and to what extent users are able to exploit a book and journalistic article for their purposes, their usually private purposes. Here we have a possible tension because the author or copyright owner might, might be, the publisher, for example, might be reluctant to give this permission, right? So disputes involving publishers have often covered the use of copyrighted works for educational purposes, for example, right? In this very old case, US case, Macmillan versus King, the judge held that an economics tutor's reproduction of excerpts from a textbook, which were contained in the study notes that he freely provided to his students, did not amount to fair use. Students should have bought the book. In another, even earlier case of the 19th century, the Folsom versus Marsh case, actually this was the first fair use dispute in the US. It was between publishers. And it was a case about the use in a George Washington biography of parts from his letters that were previously published in a collection of the late US president papers. The judge found that copyright was infringed because significant big amounts, big chunks of the work were taken, which diminished the value of the original work, right? And then we have the Indian case I mentioned before. University of Oxford and others versus a photocopy shop, Rameshwari photocopy shop at the University of Delhi. Here, publishers such as University of Oxford or UP, they tried to, prevent a photocopy shop in Delhi from regular mass reproduction and, circulation of copies of their books in the form of study packs to students of Delhi University. Well, these publishers believed that this activity was not fair use because the photocopy shop was selling such course packs at the detriment of the publisher's business. The students were no longer, buying from the publishers. They were buying from these photocopy shops, the study packs. Well, the judge sided with the photocopy shop. And I quote from the ruling. He said, copyright, especially in literary works, is not an inevitable, wholly natural right that confers on authors the absolute ownership of their creations. It is designed rather to stimulate activity and progress in the arts for the intellectual enrichment of the public. Copyright is intended to increase and not to impede the harvest of knowledge. Very clear position. Let's move on. Nowadays, in the COVID era we are currently living in, more than 1 billion children in over 186 countries have been out of classroom due to the global pandemic, to the restriction of the pandemic. And therefore, there has been a surge in e-learning being conducted via digital means. What has been the strategic response to this? Well, publishers have become a bit more flexible by expanding their fair use policy. Okay? So, for example, some publishers have allowed teachers to post copies of their books, of their material, in platforms such as Google Classroom or Schoology until the close of the school year. And therefore, thereafter, they need to remove from this platform the copies, which is a quite surprising turn of events. Previously, publishers, have been very strict. So, but this pandemic has made them more flexible, right? Which is, I think, a very good development, I would say, right? So publishers here, at least some publishers, they have decided not to risk any kind of negative ruling by a court, but to open up, to make their corporate policy a bit more generous, less rigid, more flexible, by allowing million and million of students to, and teachers to replicate, to duplicate, to copy, and to upload the copies on these platforms in order to, cope with a very extraordinary situation. And I also want to just conclude with the newly created publishers' rights in the European Union. In 2019, a copyright directive was adopted in the EU, which has created the so-called publishers' rights, a sui generis right. It's basically a royalty, so it's a compensatory right for publishers which can claim payments from the so-called news aggregators. You may, of course, know news aggregators on the internet. They provide us with the news or pieces of news putting together, right? They aggregate news coming from different publishers, from different newspapers around the world. Well, it has been an activity which has been around for many years now. Of course, publishers are not happy about that because their contents, copyright protected contents, is used by news aggregators also for commercial purposes, because these news aggregators, they also have some advertising banners in their website. So, it's an indirect commercial use of someone else's copyrighted content. That's why these publishers' rights has been created. Basically, news aggregators, whoever uses such, news, they need to pay an amount, a tax. So they can use it. They don't need to ask permission, but they need to pay. So it's a compensatory right. Well, the introduction of this new sui generis regime has attracted criticism because news, while a journalistic article commenting on a news is, of course, copyrightable and should be protected, short news snippets might be considered as raw facts. Under the Berne Convention, they may also be considered as uncopyrightable. So where do we draw the line between comment of existing news and news per se might be blurred. And we will see in the following years if this publisher's right has worked or not. The previous experiences from Germany and Spain are not so, do not leave as so optimistic, I would say, because it seems that this new sui generis right has not worked very well. So this was my last slide, but not my last slide is dedicated to the city of Bangalore, and I am open to questions and comments, everything.